My experience suggests that many times, especially in the last few months, when people have gone suddenly due to COVID, so they did have a will, but it was not sometimes registered. When it was not registered, the bank specifically, they started asking that, get a registered will, or instead of that, get a succession certificate. So it is confusion. There's a lot of confusion whether a registered will is required. Why, if it's not so mandatory, why does the bank ask for it?
Sure. So let me clarify this and hope this will make things clearer. Okay. So registration or unregistration will is basically of the document. Okay. If it is to prove the authenticity of the document when it goes into the court, it has got nothing to do with the succession certificate or a probate order. Okay. Even if it's an unregistered will, okay, a bank will still say get a succession certificate. Registered will, they will still ask for succession certificate. If it falls under that criteria, okay, they have certain minimum amount criteria. If the amount is beyond that, they will ask for it. Okay, so each bank will have its own rule. But for all practical purpose, most of us will fall in the category where this certificate will be required. Okay, so registered will or unregistered will, succession certificate will be asked for. Now there's another document called as the probate order. Okay, now when there is a property, okay, and when the asset size is big, okay, and if the person is staying in 3 places, okay, Chennai, Kolkata, and Mumbai, or has a property in one of these 3 places, okay, then the bank will say, get me a probate order. Okay, so probate order will take care of succession certificate also.
Okay.
If you've got the probate order, you need not take a succession certificate. Succession certificate is basically a subset of the probate order. Okay, because probate order is of the entire estate. Succession certificate could be specific to your account, to your investment. Okay, that is very specific. You may say, okay, these are the bank accounts, these are the FDs, please get this as a succession certificate. But if you have a probate order or a letter of administration, okay, now let me distinguish between the probate order and the letter of administration. When a person has written a will, and if it's a valid will, okay, then you go and get the probate order on that. But if a person has passed away without writing a will, okay, or the will for some reason has been held invalid, okay, then it's a similar process where you go to the court and apply for the letter of administration. Okay, this is a court's way of ensuring that the person who has come to apply, okay, is authorized,
correct. Yeah.
and who are the legal heirs. Okay, so court has its own process of authenticating, and then it issues this order. Okay, and this order is the court order, and this order is what the court will eventually, I mean, all the banks and mutual funds and insurance company will go by, and they will honor this, including the property registration in the beneficiary name also.
Okay.
Right? Yeah.
So yeah, that answers the question.
Sure.
So you brought out some very interesting points, which we were not very well aware of. One is like, what is this? How do you go about getting a succession certificate? Many people are very confused, and it takes a long time. That's what I've understood. It takes almost some few weeks to maybe sometimes months also.
Yeah, it does take long. In fact, it takes average 3 to 4 months. Okay, it's a very similar process of like taking a probate order, because it is issued by the court. Okay, in most of the metros, the authority of the court. In certain interiors, there's a Talati office which issues it. Okay, but since we are staying in metros, it is the court, your district court, which will issue this order certificate. Okay, now. When this situation happens where near and dear one somebody has passed away, the first thing to find out is succession certificate is good enough, or I need a letter of administration, or if I have a will, I need a probate. Okay, many a times I see that people only get a succession certificate which talks about only 3-4 bank account, mutual fund. What about the other assets? And I say you could have gone and straight away got the probate order, because for probate or a letter of administration. Okay, so first thing is to find out which is that document, okay, which will be required. Okay, so once you know that this document is the requirement, then you go and apply in the local court. Okay, And then that court will eventually have a process of authenticating. They will send a letter to all the other beneficiaries. They will get a consent from them. There's a whole process. Okay. The lawyer will be able to, I mean, who's dealing with it will be able to eventually do the whole process. But the court issues this document. So succession certificate, as well as your letter of administration, as well as your probate. Okay.
Okay.
All these three documents are issued by the local court. Okay.
Okay. So I have one more question. In fact, there are many questions on this point now. I'm unable to go to other questions till then. They are asking, in case the bank account is a joint account and primary account holder passes away.
Yeah.
Does the secondary account owner need a succession certificate to become the primary account holder? I don't think so. Am I right?
No, no, not needed. Not needed.
Okay.
Not needed.
Okay. So moving along to my next question, you have already spoken, and thank you so much, because this was a really confusing topic for even me. You know, it is so unpredictable that how long the succession certificate will stay, and you know, very, very difficult.
Yeah.
Okay. So will is one way to transfer your assets.
Right.
You know, there's a lot of confusion, Mr. Shailendra, about nomination and, you know, a will. Many people feel that we have made nominations, so will ka zarurat nahi hai. You know, they say कि we have nominated our so-and-so child for so-and-so account or so-and-so mutual fund. So we do not need to make a will. Tell me, what is the difference between a nomination and a will?
Okay, so this is a really good question. And I think many have this whole doubt about the nomination versus will. I'll try to make it as simple as possible. Okay. So first thing first, if it's a joint account holder, once one of the holder passes away, the survivor will take the control of the asset, right? Only when it's a single hand account or both the holders have passed away, now we move to the nomination. Okay. Now, who's a nominee? Nominee is basically a caretaker or a trustee. Okay. Nominee may or may not be the beneficiary. Okay. Which means that all the accounts, all the insurance, mutual fund, where we have somebody, we have made a person as a nominee. Okay. He may or may not be the ultimate beneficiary. So nominee's job is to collect the assets. Okay. If he is the only beneficiary, then he keeps everything. Simple. But many a time there are multiple beneficiaries. Okay. His job is to collect the asset and distribute it to the other beneficiaries.
Right, right.
Okay? True. Now that's where many people get confused. Look, I am nominee, so it's my wealth. It's all me. My father has made nominee in this account, so after him, it is my asset. No, that's not correct. It's not your asset. You are only supposed to collect the asset and distribute as per the will or as per the succession law, which I just talked about initially. Okay. So that's one part. Second part, unfortunately, in India, it does not apply to all the assets. Okay. So there are some exceptions also. Right. Now, which are these exceptions? Okay. Epf accounts. Okay. Epf accounts, if you have made your spouse, your children, or your parents as a nominee, okay, they become the beneficiary. In the absence of will, if there's a will, then will override this also. Okay. But if there's no will, okay, and if you made your spouse, children, or your parents, and if your will not allow you to nominate anybody other than these, okay, they become the beneficiary. So then the question of passing on to other beneficiary does not arise.
Does not exist. True.
Similarly, insurance policy. There's a concept of the beneficial owner. Okay, in 2050 there was an amendment. Okay, wherein in the insurance, if you again, okay, nominate these three relationships, okay, your spouse, your children, and parents, okay, which is called as the immediate family, same rule applies here. They become the beneficiary.
Yeah, that is the question of insurable interest out there. You cannot, you cannot give the insurance policy in somebody else's name. It has to be an insurable interest there.
Insurable interest, and the nominee, if are these three, then they become the beneficiary. Correct? But if you have nominated anybody other than this, let's say a friend or a distant relative, then that person only will have to collect the asset and distribute as per the law, as per the succession law. So this is applicable only when you have made the beneficial owner or beneficial nominee. Okay, that's where this is there. Earlier, there used to be confusion on the demat account, but there's enough clarity on that now. Okay, so there's no confusion on the demat account. Demat account also has the same rule wherein the nominee is only the custodian or a trustee, and they are not the ultimate beneficiary. Okay. So nominee only ensures, and also one last point, banks will always insist on making a nomination, and that is good, and that is what we should do. Because one important thing which happens when you make a nominee is, okay, and I want everybody to note this, that you do not need a succession certificate if you have a nominee. Okay, you do not need a probate order. You don't need letter of administration if there's a nominee. Okay, straight away, you go to the bank, you go to the mutual fund, you go to the insurance company, they have some documentation, okay, certain indemnity and all those bonds and all, sign that, the money will go to the nominee within a week to 10 days time. There's no need for succession certificate. But as I said, the nominee will only collect the asset and distribute as per the, okay. So the liquidity gets immediately provided.
That's a very strong point that you made.
Right.
In fact, along with it, if I may add that even if you have made a nomination, I think it would be a worthwhile exercise to go and check once that whether your nomination is correct, the spellings are correct, the date of births are correct, because sometimes even on these small issues, the assets are rejected to be transferred. So that's a very wonderful point. The next one that I have a very interesting question, although it may not apply to all, I do have some NRI clients sitting here. So if a person is an NRI and is a resident of, say, US or UK or anywhere else, will it be, if he has made a will it be valid in India, or does he have to make another will? Especially, of course, it goes without saying he has assets in India.
Sure. So the validity has to be checked from country to country. Okay. Most of the country honor the will of the other countries. Okay. Unless there are some specific requirement which you do not fill. So if you have assets in various countries, you should be aware that will this will of mine, okay, will go through in the court of the US or a UK or not. Okay. Most of the cases it is, okay, because R is as per English law and it takes care of everything. So most of the cases it is, okay. But having said that, if you are somebody who's got a decent assets in offshore, it is very strongly recommended that you write a separate will for that country and separate will for India. Okay. Now, why? Let me elaborate a bit on this for two specific reasons. One is that these two wills will be as per the local laws. Okay, so you're ensuring that the will written by in US is by attorney there. Okay, and as per the law, he will take care of everything. Okay, and in India, you have as per Indian law. Secondly, apply in the courts. Okay, and I had actual case wherein there was a large family who had around £3.5 million in London. Okay. And just 20 lakh in one of the bank account in Noida. Okay. The whole estate was stuck because there was a long delay in this probate order because it's a single will. It has to go through the probate of a country 1. Then it has to go through the probate of a country 2. And then only the estate gets closed. Okay. Whereas if you two will, you can simultaneously apply in these two countries. Okay. And whichever you get first, you distribute.
Okay.
Right. Otherwise, the same will has to first of all pass through so it went within 2 weeks, 3 weeks, maybe in the London, but when it came to India, it took 2.5 years. Okay. So even the assets lying in London was held. Okay. It was not distributed because the will was not fully executed as per the will. Okay. So as I said, as far as possible, one should make 2 separate wills for 2 separate countries.
Okay. And what happens if the legal heir himself or herself is in US? Do they have to come here to, especially if the person has died in a state, do they have to come here for a succession certificate in India?
Actually not needed. Okay,
Mhm.
there are process through which the whole process can be done from the US also. Okay, there is some attestation which needs to be done. So in the local embassy, they can go and attest those documents. Okay, so there's a process which is in place. They need not necessarily come, provided they have somebody in the India to do whole legwork, whole paperwork.
Okay.
Okay, if they have somebody who can do whole work, then it is actually not required. Okay,
Okay.
it can be managed. It can take time. Okay, but it can still be done.
Okay. So you spoke about nominees, right? What
Sure.
happens if, if the nominee is not of immediate family and, just for convenience sake, it's somebody from the extended family,
Sure.
right? And if the assets are allocated to the immediate family, then I guess I've understood this question also, and possibly you've already answered it. Possibly, if the assets have to go to the immediate family, then the nominee will only do the work of distribution or take the assets in his. Okay.
Correct.
Very
Correct.
nice. Right. So I think that answers their question completely.
Sure.
Okay. Apart from wills, we are speaking about wills, but there are certain cases, where there might be a requirement of other ways. Are there any other ways that one can transfer their inheritance to their loved ones?
Yes. So one is obviously the joint account and nomination. So in a way, you have actually transferred your asset, okay, by doing a joint account and nomination, provided the nominee is the ultimate beneficiary. Okay. Third is there is a way of family settlement which some families do. Okay, so that at least gives a clarity, though you still have to go through a whole legal process of ensuring that the assets are passed on in a proper manner. But family settlement is also one way which some of the families transfer typically their financial asset and their business shares and all. The other is the trust. Okay. And worldwide, trust is a very widely used structure to pass on the estate if you do not want the dispute between the legatees to happen. If you foresee that there are chance of dispute, then we advise that you do a trust. What to do in the trust is that a person, when he creates a trust, during his life or her life, gives these assets into the trust. Okay. So the ownership has moved from this individual person to an entity called as a trust. Okay. And the trust deed captures about how will the distribution would happen, who will get what, for how long the money should be held into the trust, all those things. Okay. Now, when this person passes away, since he's not owning it, okay, it does not form part of his or her estate. Assets have already moved into the trust, and after the assets moving into the trust and after this person passes away, okay, the wealth will be distributed by the trustees without any probate order, without any court order, okay, without any succession certificate. As per the trust, the asset goes passed on to the beneficiaries. Okay. That's again one very popular way of passing on the asset, because in this case, you are ensuring that you don't have to go through the whole process of will and the will getting challenged. Okay, because you've given away asset during your life into a trust, and the trustees will take care of the assets after that.
Okay. So regarding the trust, there is a very interesting question that is coming to my mind. Supposing somebody is there, like everybody is not normal. So supposing someone is there who has a disabled child or mentally challenged, child with them, and he is the only child, or even if there are 2, 3 siblings, but as a parent, that person would like, some provision to be made for this disabled or the maybe a widowed daughter. In Indian families, this happens. So maybe a widowed daughter who is not getting married again, or a disabled child, or a mentally challenged child. So how can they secure, like what can they put, what kind of streams of income they can put, or how can they protect the interest of this child?
Yeah, so this is called a special child's trust. Okay, this is very highly advisable for such families. Okay, what parents do here is that parents create this trust. Okay, for the benefit of this specially needs child. Okay, wherein during the life, the parents would have full flexibility to pass on the asset and withdraw and distribute. They themselves can be beneficiary. Okay. So they can keep transferring the assets as the liquidity allows them over a period of time. And some of the assets will go through a will into this trust. Okay. Now this trust, okay, will ensure that the requirement of the child is being taken care till the time he or she is alive. Okay. Now the most critical part here is finding the right set of trustees to implement it. So you have created a structure, you have moved the asset, but the biggest concern which the family faces is that how do I ensure that these assets are eventually used in the right manner, in the prudent manner for my child. Okay, that's where you need to search for the right set of trustees. So there are many companies who become trustees. Okay, our own firm acts as trustees. There are reputed people, trusted family members. One has to be very careful because there could be a conflict of interest. I mean, you may think that, okay, this uncle, this relative, sibling, okay, because let's understand this person will not be able in position to question if something goes wrong. He may not have a mental capability to even know that something has gone wrong, and he or she may not even know that there's so much money lying for me. So it is very critical to choose the right set of people and not 1, 2, 3, 5, so that there is a checks and balances. Okay, people of high repute, okay, whom you can trust. If one of them is doing something wrong, the other questions. Okay, so that's where this structuring and this planning goes. And in my career, I've done many such trusts. Okay, and trust me, it's very, very sensitive and very tricky thing to handle because what should be the role of the siblings, close relatives? You may want, but then we say no, avoid that. Okay, today the relationship is excellent, but you don't know what can happen.
You never know. Yeah.
Okay.
Looking at given Indian families.
Yeah. So I mean, this is not easy topic to handle. Case to case, family to family, we have to advise them. But that's the structure. Okay, that's the structure, and that's the structure which works well. Okay, there's some cost to it, but that's the solution. Instead of trusting any family member or relative to take care, I mean, that's obviously most of the families do. But creating such a trust is what I think is highly advisable.
Yeah, thanks. That's wonderful. In fact, see, as I said, it's a very hot topic and it's really interesting. A lot of people are coming up with so many questions. I don't think I can answer all. I mean, take up all
pleasure.
of them.
My pleasure. We can go on.
I'm so sorry. So sorry. I think we are taking up a lot of time.
I enjoy talking about this subject, so I can.
But we are having a wonderful time, a session with you. All my people from their side, I would like to thank you. So in fact, I would like to add that, when it is a matter of so much of, importance and something which is going to be there even after we are gone, it makes sense to take professional help wherever required. And the language of a will definitely matters. So if you want to write a will yourself, it's okay. You can actually do it, but the language should definitely be correct. One more question which has come to us from one of our clients all the way from Gujarat. He is asking that, he has, say, he wants his inheritance to go to, say, a person, his family member, and he's appointed an executor too. Now, suppose the situation happens where he passes away and the executor too passes away. So how is it now going to get, passed off? The assets will be passed off to the...
Good you have brought this point, because this allows me to spend some time on the executor of the will. Okay.
Yes.
When you make a will, okay, most apart from the beneficiary, of course, one of the most critical part is to appoint somebody as an executor. Okay.
True.
And if you do not appoint an executor, okay, then the first thing which will be done is the court will ask who's an executor, then the beneficiary will have to together, okay, agree and ask somebody to become an executor. Okay, so the first step is to now find out who's the executor. Many times usme ladai ho jati hai, who becomes the executor, because if there are 3 or 4 beneficiaries, everybody wants to become an executor, because executor has a power to sign papers, transfer the assets. Okay, so it is very critical that we decide who will become the executor. Now, who can be executor? Okay, beneficiaries can be executor. Absolutely, there can be more than one executor. If there are 2 or 3 of your beneficiaries, you can make all of them as executor. Okay, companies can become executor. Okay, in India, this is not still very popular, but we ourselves are executed to many wills. Okay, the companies who would be in all, I mean, probability they'll be neutral and they'll be independent and they do the job because that's where they're supposed to do, can become the executor, obviously against certain fees. Okay. You can make any distant relative, any person as an executor. Okay. Now coming to your core question. Okay. If your executor passes away, ideally you should amend your will and make somebody else. Okay. So as a thumb rule, we always say that make a person younger to you as an executor, so that the chances of he dying before you is less. Though nobody knows, but the chances are less, right? Okay, so make a person younger to you as a executor. Rule 1. Rule 2, if you want to be sure, make 2 or 3% as an executor. Okay.
Okay.
Advice number 3, in the will you can write, I'm making A as an executor. If A passes away, then appoint B as an executor, if B, then C, then D. You can actually keep on writing. Okay. You can actually add that, right? The will allows you to add, say, if he or she predeceases, then so. If so and so predeceases, so you have option to do all that. Okay. So do that in case if you wish so. Now, if still after everything, both the executor are no more. Okay. Then as I started my question with, answer with, okay, then the beneficiaries will have to come together and go to the court and ask for saying that so-and-so person will become an executor. And hopefully they agree that who become an executor, and that person applies for being an executor. So court will have its own process of verifying, and then it will appoint that person as an executor. And then the executor will go and file for the probate. Okay, so one step gets increased, wherein appointment of executor is now one important step, because the will, unfortunately, person are not there. How many times people do not write executor? They don't even know that there is need to write anything. Okay, so in all such cases, there is an appointment of executor. Which
Mala Singh ka phone. Mala Singh ka phone chhod di nahi.
May I please request everyone to kindly mute their mics? Okay, there's one more question regarding this, which we were talking about. Is there something called a living will? Is it possible to transfer your property or assets into your child's beneficiary's name while you're alive? Like, it would happen. I think I can understand this question, where it's coming from. Maybe there's a situation where there's a parent and they fear that, they want to give their asset to, say, one particular child, and they fear that the other child will also be party to it. So they want to transfer it in their lifetime. So how does that work?
Okay. So what you said, living will, is actually a gift. Okay. When you give your assets during your life to your loved ones, anybody, is actually gifting assets. One question which people ask me is, should I give during my life or should I do it through a will? Okay. So the answer is, if the asset which you are going to gift, okay, is the house which you are staying in, if you will require this money during your life, then do not do it during your life. Okay. Do it through your will, because many a times, and we live in a world where once you're given away the asset, then the children will not take care. Okay. You lose the power. Okay. You lose the control. And there are many cases. Okay. And there are cases where the gifted asset has been asked by the court to return back. Okay. So there are such judgments also which has come. Okay. But having said that, you do not want to get into a situation wherein you give away the asset to your children during your life, and then children don't take care of you. Okay. That happens. But if you're somebody who's got 6 houses, you want to give 2 of them, go ahead. Okay. You've got tens of crores. You want to give 5-10 crore during your life, do it. But you should save enough for yourself and for your spouse. Okay. So gifting of asset is what you talked about. Okay. So do I do it during life? I mean, it's case to case basis, but this is my advice. Now coming to a living will. Okay. Living will actually is slightly different concept. Okay. Living will is a concept which is new to India. Okay. Living will is a will wherein I appoint somebody, okay, who would have a option to decide what would happen to me if I'm terminally ill. Okay. Should the ventilator be pulled off?
Oh.
That is a living will. Okay. So we have talked about this euthanasia and the whole thing. Okay, there's a whole debate which is going on. In India, it is still, though there was some court order which came, but we have a long distance to travel before we have a clarity on this. Okay, because I mean, it's a double-edged sword. If you give a power, then it can be misused. Okay, there may still be scope for a person to survive, but this person decides, no, there's so much of cost, let's pull off the plug. Okay, so living will is basically giving instructions to somebody how you should be treated, what kind of process has to be followed, what consent will be required, and after that you should be allowed to decide. I mean, you should appoint that person that he will decide that, okay, the ventilators need to be pulled off, or you don't want to be stay in vegetative state for too long because it's a, so many people have this desire, but there's not much of a clarity on this. Okay, but that's the living will. Internationally, it is very valid. Okay, it's called as a medical will, is more popular word. Okay, but living will is generally used for this thing. Okay. Yeah.
Okay, great. That really was a very touchy point, and you answered it very well. Then there is, what is this, in case of a tri-party agreement, do we need to probate the will?
So see, the agreement is basically between the people who agree to this. Okay, so that is a settlement thing. But when the assets are still owned by me, okay, that has to be either going through a probate process if there's a will, or if there's no will, then through a letter of administration. Okay, those agreements are basically broad understanding who gets what, but the ownership will get transferred only when you do this. So why do I do agreement? If I'm a business owner, I want to get my children on board saying, look, this business will go to you, this property will go to you, this will go to you. Let us all together sign this paper so that tomorrow we don't go back. So there's no fight between us. Just like the Ambani's brother later on, eventually they did. Okay, who get what is a separate question, but there was an agreement. Many business families do that. Okay, so let's not confuse this document with the document of passing on the ownership after the death. You will still need a letter of administration or successor certificate or probate order. Okay, this tripartite agreement or a family settlement only ensure that your children or legatees have agreed to it. Having said that, they can still go back saying that I was under pressure. Typically, the stand which people take when they want to go back. There are many cases where fight starts happening and then the court cases go on. Right?
Okay, right. Okay, one more important thing happens that, I am say today, making a will, and I have a set of assets, right? And I have listed those assets, but over a period of time, after 10 years or 20 years down the line, I feel that those assets need to be changed, have got updated, or even, I want to change my beneficiaries. So what is the way to amend a will? Do we have to make another will, or like you did also mention that the last will is supposed to be the most valid will? So what is the way to amend it if I don't want to redo it all over again?
So there is a term called codicil, which is basically amendment is the word. So if you have a will and if you want to make a small changes, maybe adding a property and just some small changes, then you can do a codicil. Okay, so that gets attached to the will. Okay. If your main will was registered, then the codicil also has to be registered. Okay, right? Then only it becomes a codicil property. Okay. Now, if there are slightly larger changes, you are changing the beneficiaries, there are more assets to be done, then we advise that let's do a new will. Okay, because the most recent will, as said, is the valid will. Okay. There's another way to do it. Maybe more smarter way to do is that what we do is we actually have a schedule of assets. Okay, so schedule of assets becomes the part of the will. Okay, so if there are small changes, we only change the schedule. We do not change the whole will.
That makes sense.
There is way to do that, but obviously that document needs to be properly signed and executed and all. Okay, so these are ways, but if there's a substantial change, then we say that we do the whole will again.
Right. Yeah. Okay. So one more important thing is that, many of us are inheriting properties after our parents pass away. Suppose I inherit a property and I want to resell it, sell it off. So I have inherited it through a will. Now, do I need to go and re-register the property? Then only I can sell it, or on the basis of the will, I'm able to just make the sale.
No, no, you have to register and take the ownership in your name.
Okay, I hope that answers the question. Someone had put
Other
up.
party will not buy the flat when it is still in the deceased name. It has to be in the beneficiary's name.
And in case of a transfer of assets to spouse, one of the spouses has passed away. Is a succession certificate required? There's no will, but a succession certificate required, or only relinquishment by the children is enough for the transfer of, because the children would also be nominees, or would be not nominees, but would be the beneficiaries. So if there is a case happens where the spouse has passed away, one of the spouses, then by relinquishing their right, can the property be transferred to the spouse, living spouse?
Okay, so this is basically, there's a document called as a release deed. Okay, release. Okay, where you release, you give away your right. Okay, so that is also something which is accepted, but you'll have to check if that society or that property will accept the release deed. Okay, I have seen lately many societies say that we actually want a probate order or a letter of administration. Okay, these release deed will not be acceptable because one can go back on, though it is a fairly valid document. I mean, in Bombay also release deed works in many cases. Okay, successor certificate is generally for the movable assets. Okay, the moment you have an immovable asset, then you need to get one of these documents. Okay, right? So that's very critical. Successor certificate, you can't have a immovable asset.
Okay.
So these are the technicality part of it. That is why I said, I mean, you need to find out which document you need. Okay, that is the first and the foremost thing, and then go and obtain that. Okay.
So that was great, Mr. Shailendra. I think we have answered most of the usual questions. There are certain questions which are very specific to some people. I would only request them to get in touch with us, back with us, and I will surely connect you to Mr. Shailendra. I'm sure he will take out his time and help us out.
Sure.
For everyone's benefit, Mr. Shailendra is a part of us, is on board with us. And if you want any guidance or to get your will made professionally, thoroughly professionally, then he is the one to go to. We are going to share our phone numbers. We are going to share even the places where you can follow us. A lot of people are asking this question, that is there a format to a will? So, well, we have put a draft format on our website. One can just go there under the download section and take it out. You can just fill it up, and then after that, you have to share it with us to go further. And Mr. Dubey, his company will take care of that. Apart from that, many people are also asking me that you should have more these kind of sessions. Thank you so much for this thing. We consistently post a lot of content on our website, on our YouTube channels, on our Facebooks, on our Instagram. Do follow us, subscribe to us. The links are being shared on this messaging. You can go there and share. You can go there and start subscribing to us. You will get a lot of content. We keep having a lot of Facebook lives, although last time we tried it and there was some technical problems. So we decided to stick to this staid old boring Zoom, but this is most useful. So these are the things that we wanted to touch upon. As we go off, I would want Mr. Dubey, anything that last parting words that you would like to talk to my clients, because this is such an important topic in these COVID times. I would like you to leave us with some wisdom, some pearls of wisdom.
Sure. So let me start by saying that this kind of session are the first and the right steps. Okay? You've taken a first step by joining and being a part of such a session, because the whole idea is to realize the importance of it and start acting on it. Okay, so that's very critical. Second is writing a will. Obviously, you can get format. You can copy somebody's format. People do that, but let's understand that there are technicalities, there are wordings which if you get it wrong, okay, the whole idea may get defeated.
Oh yes,
that's very critical to understand. I mean, you spend your whole life to create a wealth, okay, and when it comes to passing on, you want to have a shortcut. I mean, you don't want to spend some few thousand or whatever amount it is for a professional help. I mean, that's not really done. Okay.
Mm.
We create a wealth, and the idea is to pass it on to our loved ones. Okay. Let's give enough importance to that. Let's take a professional help on that. Okay. And see, our firm does not only help you in writing the will. That is one very small part of it. The bigger part is execution of it. Okay. So we actually help to execute the whole will, getting the probate order, getting the success certificate, okay, whatever is needed. And eventually the most critical part of it is implementing. Okay, this succession certificate or a court order is in my hand. Now, what do I do with it? Okay, now you need to go to all the mutual funds, insurance companies, banks, and claim it. Okay. Now that's again a very legwork and a tedious process. Okay. We had a case where for a family, both father and mother passed away within a gap of 1 day. So day one, father passed away, next day, mother passed away. Okay. And assets were mainly jointly held, okay, or singly held by them, right? So we are helping the family right from the basic work of understanding what document is needed. There's a locker which was there, which we could arrange to get it done through bank. Okay, we've applied for a letter of administration. Now we will go and ensure that each assets are being claimed, okay, and distributed to the family members. Okay, so this is again a very critical part of it. Okay, so that's something which one should keep in mind, that writing of will is one, but the whole exercise is completed when we also ensure that it is implemented after you. Okay, the executor you appointed, is he or she capable, or he or she has a understanding or will be able to do. Okay, many times we appoint our spouse as the executor. I mean, at that age, even the spouse may not be able to do it. Okay, she will be old or medical issues, right? So you may need a help to do that. Okay, so that's one bit. And I think the last point which I want to bring across here is, so why do we do all this? Okay, idea is that you pass on the wealth in a organized and a peaceful manner. Okay, so I mean, 3-4 things I want to bring in here. One is prepare an asset and liability register, which means that your assets you try to list down. Okay, where are they kept? Then probably you may want to digitize them. Okay? Have a digital format of them, or there are certain companies which will keep your asset in a digital format. I mean, this information in the digital format. Okay, so one should do that. Second is complete the paperwork. Many a times we've seen when we are an executor, the paperwork is not completed, the document is not in place, especially related to the properties. Okay, go back, see what are these papers which are needed, complete that during your life. Okay, if you have taken a loan, or sorry, if you have given a loan to somebody without any documentation, complete that, because when a person passes away, the first person to say no is the person who lended money.
This was a very important point. In fact, even
there is nobody. How will you prove that? Correct. How will you prove that? Have a documentation place. Have a document signed and agreed that this is the loan which was given by you to him. Okay. And final point is resolve the family disputes during your life. Okay. Nobody wants to inherit the family dispute or family fight. Okay. As far as possible, don't pass on this family dispute and this family fight. Resolve during your life. I've seen so many cases where the property matters goes on from generation to generation. Next generation keeps fighting. The relationship goes bad. Okay. So try to resolve if you can during your life. There is nobody would like to inherit such disputes. Okay. So I think that's from me. It's a pleasure being part of this session, and I hope it was useful.
It's been a pleasure to have you, and a very, very informative session. It has cleared so many cobwebs which we had in our minds. This is something really which is the need of the hour, and everyone should, although it sounds a little ominous, we should not be talking about death, but we should not take it as death. We should talk about actually we worked all our lives. It should be just transfer of assets to the right people. And that too, as we want. We lead our lives on our own terms. we should at least ensure that the transfer also happens on our own terms. Secondly, as I had said in the beginning, it is important to ensure that there is no legal hassle. A will takes care of many things. The lengthy processes which are there for legalities which are there can be taken care of by a proper registered will. Things would remain, succession planning and all these things would still remain, would be an issue. So thank you so much, Mr. Dubey, for being a part of us. We hope to have more association. As I said, he is a part of my company now, and we are like working as partners. And I would definitely be troubling you more on this.
Anytime.
Thank you so much. For my friends, thank you so much for being here in such a large strength. It is really heartening to see that so many people are there, and more heartening that this is such an important topic and everybody is concerned about it. So do follow us on our YouTube and Instagram and the Facebook. As I said, the links are there. You will get more content. You can join us. Join me again on Sunday. We have another webinar lined up, but this time it is on investments. If you want, you can join us. We will definitely send you the link. Thank you so much. Thank you again, Mr. Dubey. Thank you for being part of us. Thanks a lot and have a great evening. Bye-bye.